Good afternoon and welcome to Legal Access, brought to you by the McGuire Law Firm. Each and every Thursday we give you an opportunity to ask questions about different aspects of the law. Today we're talking about premises liability, which is just a fancy way of saying if you get hurt on somebody else's property or somebody else's premises. That's what we're talking about here today. If you have any questions about slip and fall accidents, trip and fall accidents, which are different, or any kind of questions like that, please give us a call. Phone number's on your screen, 843-848-8080. Here to answer your questions today, first of all, from the McGuire Law Firm, is Mike Smith.
How you doing, Dave?
Doing good. And in addition to premises liability, McGuire Law Firm deals with what other aspects of law?
Auto accidents, things of that nature, medical malpractice, a little bit into that. It's a wide range of plaintiffs' work.
And to your left to answer questions today as well is going to be Rick O'Neill from the O'Neill Law Firm. And Rick, in addition to premises liability, you deal with what?
Workers' compensation, automobile. We do a little bit of medical malpractice as well.
So we're well equipped to answer all of your questions. Don't be shy, give us a call. Got 30 full minutes on this show, about 29 now if you're really keeping track, but still, give us a call, we'll get you on the air. All right, we've had a lot of rain over the last several days. You walk into a store, a restaurant, a store, a shopping center, grocery store, you slip and fall at the threshold of getting in the store. Is that an automatic lawsuit?
It is not automatic anymore. Our appellate courts have basically said that you're put on notice that the floors might be slippery if you walk in and it's raining. That's really not where you get most of your problems. You get a lot of problems with slippery floors inside let's say a grocery store, because you come up to the refrigerated section of the produce or
Right.
meat or something like that, and then the refrigerator may break down. There'll be a big leak in the floor, and I've seen people have lawsuits arise out of coming around the corner, not being put on notice of that leak, and slipping and falling. So it's not really the weather issue that is the big gun, if you will, but it's what happens inside the store,
Right.
and what's under control of the store's management.
Yeah, talking about substances on floors, one of the landmark cases I like to use as an example for my clients is the South Carolina Supreme Court in a case, a big box grocery store. There was a puddle of water like 10, 15 feet away from the cashier, and the plaintiff slipped in the water and injured themselves. And the court said, dismissed the case and said that unless you as a plaintiff can prove that the store had some type of notice, or that they are the ones that deposited the water on the floor, then you can't prove your case, and the case was dismissed. So it's an uphill battle. It's not as easy as people think, just simply because you get hurt at a store that you
Right.
automatically win your case.
And if a store actually puts out a big yellow cone that says caution slippery, they're actually admitting that they actually know that there is a hazard that's there.
They are, and they're putting the public on notice that that hazard is there as well. One of the things that South Carolina law, that's in the South Carolina law, is that we have something called comparative negligence. So in essence, the courts have indicated that you've got to take care of yourself too. You've got to be aware of your surroundings. You've got to not be negligent yourself more than 51% or more than 50% in order to collect. So, you know, you do have a responsibility. Rick was talking about old cases. One of the most devastating cases that I ever had, now I was on the defense side in that case, but a wonderful lady was walking into a hotel, to one of these condo hotels, to look at a unit. And while she was inside that unit, the Homeowners Association's maintenance people put down a welcome mat. Well, that welcome mat was one of those nice thick new ones, and it took the place of the thin rubber one.
Right.
Well, she's in there, she's looking around, and she starts walking back out again. And as she walks out, the muscle memory doesn't tell her that there's something on the other side of that threshold. She trips, falls, stumbles forward, reaches out, and breaks her humerus bone.
Right.
She has 3 different surgeries on that bone. We get into depositions, Dave, and she takes her sweater off and she lifts her arm up and it bends. But it bends not at the elbow, it bends at her humerus bone. And I'm thinking, Lord have mercy, when the jury sees that, they're going to go ballistic. Well, we went to jury trial. We got to trial. The lady took her sweater off and showed the jury. I heard the gasps and the oohs and the ahs. And the jury went out, and it was less than 30 minutes later, there's the knock on the door, and the
Right.
jury comes back in. And it was we, the jury, fined for the defendant. I was like, Lord have mercy, an injury that bad, how could you come up with a zero? And I talked to the foreman, and his comment to me was shocking. He said she should have watched where she was walking.
Yeah.
So you do have a responsibility to take care of yourself. But now I will tell you, for every case like that, there's a case on the other side. So don't be totally discouraged if you get a slip and fall or
Right.
something happens like that, because while it's like Rick says, I tell my clients it's like a salmon swimming upstream, but eventually they get upstream. So you need to look at all the facts of the case.
Yeah, just like in an auto case, the courts say that you have to be a defensive driver. If you see there's someone's coming at you and they're crossing the center of the line, you just can't stay in you have to take some type of defensive maneuver to avoid an accident yourself, even though it's the other party that's violating the law. Well, the same thing in a slip and fall. You have to be a defensive walker. You just have to be a defensive person yourself. There's duty goes on both sides of the fence.
And one
Give
of
us
the-
a call if you have any kind of questions about premises liability. Let's go to the phones right now in Myrtle Beach. Jackie is with us. Hi, Jackie. Thanks for calling. What's your question today?
My husband was mowing at someone else's house, and he picked up a bird bath, and a copperhead bit him on the tip of his finger, and he was in critical care for 3 days. I was just wondering if the homeowner, her insurance would take care of that.
That's a tough question. It's a good question. There are some states that have a wild animal situation where you can't basically defend against what a wild animal may do. I've seen it in cases where somebody would fall in an ant bed, for example, and the ants would bite them and
Right.
go into shock. Typically speaking, an insurance company is not going to want to take something like that to trial, especially when the damages are that bad.
Right.
So will they cover it? There's going to be lots of coverage opinions by coverage counsel on those types of cases dealing with wild animals, if you will. A lot of other factors come into play. Did the homeowner know that there was snakes there? Was there a prior problem with the snakes to put them on notice of
Right.
something like that? So there's all kinds of issues that come into play. It's not black and white. That's why Rick and I practice law. It's gray. It's not black and white. But if something like that happens, I would definitely turn it over to the insurance carrier. I would
Right.
ask them to cover that. And if I were the victim or the plaintiff in a particular case like that, take the first steps to pursue it, see what happens.
Sure.
And just, we were just talking about comparative negligence. Did the claimant know that there were snakes there? It's not only, did the homeowner, but did the person, is this the first time they're cutting the grass? Or have they cut this grass several times and they knew there were snakes in there? Should they have known themselves?
Generally speaking, as far as being on somebody's private property like this, I mean, if you go to somebody's house and you walk up their stairs and there's a loose board and you fall and you injure yourself and you've got medical bills, if you try to get any kind of recovery from that, you've got to basically sue the homeowner's insurance, correct?
Well, you don't sue the homeowner's insurance, you sue the homeowner.
Right.
And a lot of people don't understand that factor. You're not necessarily looking to pull finances out of somebody's pocket.
Right.
But it's the homeowner's insurance coverage that will step up and defend the action. The insurance company hires the attorney to do the defense work. But you'll make that claim against the homeowner's insurance company. If you can't settle the claim, then you'll file a lawsuit against the homeowner,
Right.
and then the insurance company will come in and defend.
Jackie, if you're still there, my advice would be to call a personal injury law firm, because personal injury law firms work on contingency, so it's not going to cost you anything to get a free consultation. So find somebody, call somebody, and get them to give you an opinion and work from there. And hopefully your husband is doing better after that. Being 3 days in critical care from that is not
Right.
not a joke. So yeah. Tell you what, we're going to run to a break here real quick. When we get back, we'd love to take your phone calls. Give us a call right here. The phone number is on your screen. We're talking about premises liability. If you've been hurt on somebody else's property, slip and fall accidents, things like that. That's what we're talking about here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access. We're talking about premises liability today. If you've been hurt on somebody else's premises, slip and fall accidents, trip and fall accidents, things like that. If you have any questions, the phone number is on your screen, 843-848-8080. Let's go to Myrtle Beach again. Renata is on with us right now. Hi, Renata. Thanks for calling in. What's your question for the panel? Go ahead.
I had surgery about 9 months ago, and the surgery was on my lower back. And I'm getting worse and worse. I can't walk anymore, basically. I went back there once to this doctor, and he said everything looks fine. And then I went back a few months later, asking him why I can't get out of the pain. And I was a half an hour late because Grand Strand Hospital, you can't even find a damn parking place. It's a horrible place.
Well, back injuries are complicated. There's never really a guarantee that you're going to get better after a surgery. There's issues like scar tissue that may form after a surgery, and just your spine may already be deteriorating, and then this is an attempt to solve the problem, and your spine is still aging, and the surgery may accelerate the aging process. So while it may not be a good outcome, that may not necessarily, say that you do have a case. It's complicated. You would definitely need to sit down with a medical malpractice attorney with all your medical records and have them review that.
They will typically turn that, the attorney, if you consult with one, will typically turn that over to another expert and have them look at the records, and they'll go through the surgery records. They'll look at the MRI scans and the CT scans, and they'll see if it's a natural progression of your condition or if there was anything done wrong in the surgery itself. They'll be able to look at that and give you a good idea. Yeah, and Renata, for a medical malpractice case, you have to kind of prove gross negligence on the part of either the hospital or the doctor. So it's definitely a tough case. And that's why medical malpractice cases are not as frequent or as you see some of the other cases. But yeah, consult with a lawyer and attorney and see where you can go from there. And I'm sorry to hear about your situation. All right, let's go back to the phones right now as we're talking about premises liability. That's the main topic of our show today. Melissa from Myrtle Beach is on with us. Melissa, hi, thanks for calling. What's your question today?
My question is, if a neighbor has trees growing from their yard that has poisonous sumac on it, and we've already went to the doctors about it, is they're liable for my doctor bills, or how do I get them to cut their stuff down?
Can you let us know how you're coming in contact with it?
It's growing on my side of the yard from their yard.
Okay, so you're trying to remove it and getting poisoned by it.
Yes, sir. And it just keeps growing back, and they won't take care of it on their side.
That might be something that you could pursue against them as sort of a trespass, especially if it's coming from their property onto yours. Obviously, the roots of that poisonous plant are on their side of the property line, and they can take care of it. The problem that you're going to have, though, is something that we've talked about on this show, is that comparative negligence. If you know that it's poison, you know you've got a reaction to it, what steps did you take to protect yourself? So look at it from both angles, but yes, that is something that you could likely pursue and try to get some relief on.
One thing we haven't talked about yet today is most premises liability policies, whether it be renters, homeowners, or a commercial liability policy, have a type of coverage called MedPay, where the insurance will pay a claimant's medical bills up to a certain amount, whether it's $1,000 or $5,000, whatever the amount is on the policy. And that part of the policy is no fault. You don't have to prove liability, and these issues like comparative negligence don't come into play.
Right.
If you've been injured and allegedly it's on the premises or because of the premises of the other side, they may pay your medical bills, without having a big fight over it.
And if you go to an attorney, they'll be able to find out from that other party's liability insurance policy whether they have that coverage or not.
And correct me if I'm wrong, a good idea to start with would be to have some sort of a paper trail. So if you put your neighbor on written notice, either through an email or whatever, keep a copy of that and show that you've already contacted them to let them know that this is an issue, and then move forward that way. But
Right, absolutely.
Melissa, thanks for calling in. Hopefully you can get that case settled, and hopefully you can get more information. Call an attorney on that to see where you might be able to move forward. Let's go back to Myrtle Beach. John is on with us right now. John, thanks for calling in. What's your question today?
There's been a couple instances here in the Myrtle Beach. One at a mall, a lady was murdered in a parking lot, and then there was another one at a nightclub where nobody was murdered, but somebody beat somebody up, and the guy was sued out of business because he didn't have enough security. But it seems like the mall parking lot didn't have any security either, and they basically walked scot-free. So they're just selective security, selective laws, or on premises, or just seem like the mall would have to have some kind of security cameras too to see what's going on in their lots. But the nightclub owner, he doesn't have enough security. He gets sued out of business, and nobody gets killed. But he gets beat up a little bit, but I don't know. It seems different.
What's your opinion on security as far as businesses go?
Well, there is there's not a statute that says you have to have cameras, you don't, or you do have to provide security services or not. But you have to do what a reasonable property owner or reasonable business owner would do in those cases. So you take into consideration crime in the area, past incidents on the property, and just use your good common sense as a property owner. Now, those type of things that you can do, security guards aren't cheap. The security systems are expensive and expensive to maintain. So there's a issue about weighing and so on. But generally, when in doubt, have security, have cameras. And there's a lot of resources available on the internet that will help you do a security and safety survey of your property, and especially with different industries such as malls, retail, taverns, and so forth.
Right, and you need to contact an attorney again. I hate to keep saying that over and over again, but there are so many pitfalls that you fall into if you try to do things yourself. But sometimes some of these policies that some of these bars and restaurants have, they have a limitation of liability clause on intentional acts and fights and gunshots and things of that nature. So make sure your lawyer pursues that insurance policy so they can find out exactly what those coverage limits are, because that's going to be important in the kind of situation you're talking about. The damages are likely pretty high.
All right, John, I appreciate the call. Thanks for calling in. And tell you what, I know we have some other calls on hold right now. We do have to take a break, so if you're on hold, stay there. In about 90 seconds, we'll be back and talk to you right here on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access being brought to you by the McGuire Law Firm. Today we're talking about premises liability, which again just means if you've been hurt on somebody else's premises, slip and fall accidents, trip and fall accidents, any kind of accident like that. If you've sustained personal injury, make sure and contact an attorney, because as far as personal injury is concerned, that's done with free consultations, so it doesn't hurt you to give a call and find out whether or not you've got a case that can move forward. So don't just sit and wonder about it, or you can give us a call. We've still got about 5 minutes left in the show. We've got Melody from Myrtle Beach on the line with us. Melody, thanks for being patient and holding on through the break. What's your question? I don't think Melody was as patient as I thought she was. Melody, you still there? Apparently. I don't know. I think I might hear.
I hear something.
We'll give you one more shot. Melody, go ahead and try again.
Hello?
Hi, go ahead. You're on the air.
I'm calling to find out what the statute of limitations is because I fell in 2018 and then the insurance company would never get back a hold of me.
Generally in South Carolina, the statute of limitations for personal injury is 3 years. If it's against some type of a governmental or charitable organization, usually that's going to be 2 years. Surrounding states, Tennessee, I know a car accident case, the statute of limitations is as little as 1 year.
Yeah.
But generally in South Carolina, it's 3 years with exceptions.
And then you've got minors that you have to deal with if the minor gets hurt. Until you've got that typical 3 years, but if the minor's hurt, then they've got a limited amount of time after they reach majority to bring a claim.
And she said this happened in 2018, but she did say that she was trying to get in touch with the insurance company. So she kind of started the claim, if you will, before the 3 years statute is up. Does that come into play at all?
Now, the 3 year statute of limitation, if she hasn't filed suit
Okay.
within that 3 year period and then gotten service within, 120 days later, Rick?
Right.
But the problem is I didn't know from the question whether the plaintiff, if you will, the claimant, was a minor at the time and when it happened, and that would make a difference as to when the clock
Right.
starts.
And again, each state, if this happened outside South Carolina, there may be, some states it's 6 years.
You're right, which South Carolina used to be.
And again, for a lot of these questions, when the show's over here in 5 minutes, if you have any other kind of questions about personal injury, call a personal injury attorney for a free consultation. All of them work on contingencies, so it's not going to cost you anything to blow in a phone call. We were talking about snake bites earlier with Jackie from Myrtle Beach. Let's talk about dog bites. That's always a fun one for attorneys to deal with. There used to be in South Carolina, it used to be like this semi-rule that the dog gets one free bite, but then after that they've been put on notice. I mean, what's it like these days as far as dog bites? Are you responsible for your dog if it bites someone?
Yes, you're generally pretty much strictly liable if your dog bites someone else. There are some defenses if you were teasing the dog, if the dog was protecting itself. But generally, if your dog bites someone, you're going to be civilly responsible.
And again, with these dogs, you got to be careful. And I don't want to be the bearer of bad news, but a lot of dogs are not covered by insurance in homeowners insurance policies. So again, you likely need an attorney to make sure you get that person's insurance policy so they can read it and see if there are any exceptions to the animal.
And sometimes it boils down to checking the dog's DNA to see if it's one of the excluded breeds on the policy.
Let's go back to the beginning as far as slip and fall accidents are concerned. If somebody is in a store, for example, when it's raining later this afternoon, they slip and fall on a wet spot, what do you do right then? Do you contact the management? Do you start taking pictures? What do you do?
All of those.
Yes. You do that, and you want to get something in writing, and you want to get a copy of it from the company. They'll hesitate, they'll stonewall, but do your best to absolutely get a copy of it. And you do need to make sure that there is a written complaint and an incident report and things of that nature. And ask for help. A lot of times they will be kind enough to bring you ice or something like
Right.
that, but get it in writing if you can.
And we've got just a little bit more than a minute left here. Real quick, as far as pools, if you have a personal pool at your house, are there any rules in the state of South Carolina as far as what kind of protection that you have to take at your personal pool to make sure that nobody's hurt there?
Well, have a fence and the child-proof gates. And there are add-on accessories, especially with technology, all sorts of things you can add to your pool area to make it even more safe. Alarms and things that will notify your cell phone and so on if there's activity in the pool.
And in addition to pools, something else that a lot of people have in their property are what do you call them?
Bouncy houses?
Yeah, the bouncy things, trampolines. But that's another thing, and we call them attractive nuisances that draw kids to it. So I see a lot of people don't have those things closed off, and they need to have them closed off.
That's my favorite legal term, by the way, attractive nuisance. I've been called that many times. Anyway, that's all for the show that we have here today. Next week when we get back, we're going to be talking about workers' compensation. So if you have any questions about workers' comp, you can get your questions in advance. Just email us, legalaccess@wmbfnews.com. For Rick O'Neill and Mike Smith, I'm Dave Priest. We'll see you again next Thursday right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.